You've seen trials play out on television. You've watched actors portray witnesses cracking under pressure, the music rising as someone finally tells the truth. But what I saw yesterday in federal court was not theater. It was not scripted. It was the real-time collapse of a man who understood, in a single irreversible moment, that the documents in front of him had destroyed the life he thought he could still protect. I spent 3 decades in courtrooms. I've watched witnesses lie, hedge, deflect, and cry. I've seen people gamble on sympathy when the evidence turns against them. But I had never seen this. A senior banking executive sat in the witness chair, stared at a stack of papers proving his role in a long-running fraud scheme, and simply gave up. No outburst, no tears, no dramatics, just silence. Then surrender. His hands stopped moving, his eyes fixed on the documents, and you could see the exact second he realized there was no path out. That kind of unraveling usually happens behind closed doors, in interview rooms when a suspect realizes investigators already have the truth. It does not usually happen in open court, with a jury watching, cameras rolling, and defense counsel sitting a few feet away trying to signal, desperately, for the witness to say less. The prosecutor's question was simple, almost dull. "Mr. Rotjan, Harrison, can you confirm those are your initials on the loan approval forms?" He looked down. His jaw tightened. You could see him working through the possibilities in real time. Deny it? Claim forgery? Say he didn't remember? 15 seconds passed. It felt like 15 minutes. Then he spoke. "I falsified everything for him." 5 words. That was all it took to blow up the defense. The room froze. Defense counsel went pale. The judge's eyebrows shot up. And, to her credit, the prosecutor stayed calm and asked the only follow-up that mattered. "When you say everything, what specifically do you mean?" That was when it all came apart. He talked for 47 uninterrupted minutes. Before I explain what he said, you need to understand the case. The defendant was on trial for federal bank fraud. The government alleged that he had submitted financial documents to secure enormous loans, and that those documents contained property valuations wildly above reality. The prosecution already had emails, bank records, internal files, and approval packets. It was a strong case, but largely circumstantial. The jury still had to connect the dots and infer what the defendant knew and intended. What they did not have, at least until that moment, was a direct insider confession tying the defendant personally to the falsification. That is where this banking executor came in. He had served as a senior vice president at the lending institution. His signature appeared on the approvals. His initials were scattered across the files. He had reviewed the financial statements, approved the loans, and, as he now admitted in open court, helped create fraudulent documents to make the deals go through. The government had called him as a hostile witness. They clearly suspected he was compromised. They knew he had information. But I do not think even they expected him to detonate his own career, freedom, and reputation on the stand. The original plan appeared straightforward: establish foundation, verify documents, confirm review procedures, maybe get him to acknowledge that certain numbers looked aggressive. Standard witness work. But when those documents were put in front of him, and he was asked to identify his initials, something changed. You could see it physically. His posture shifted, his breathing changed, and in that moment, he made a decision to stop running. I've dealt with cooperating witnesses before, people who negotiate plea deals, immunity agreements, sentence reductions. This was not that. He had not been charged. There was no agreement on the table. He was under subpoena, just a banking executive caught between the government's paper trail and his own conscience. And when he saw the evidence laid out in front of him, he seemed to realize the lie was no longer survivable. The documents in question were loan approval files spanning 2019 through 2022. Each packet contained financial statements tied to the defendant's properties. In the margins were the executive's initials, the ordinary markings of someone who had reviewed and approved the numbers. But there was more than that. There were handwritten notes in the margins. Notes like, appraisal returned lower, used client figure instead, and confirmed with client numbers required for approval. Same handwriting, same initials, same executive. When the prosecutor asked him to explain those annotations, he began slowly. He said the defendant had been a major client for years. Multiple loans, multiple properties, always profitable for the bank, always paying on time. A high-value relationship. So when outside appraisals came back below the valuations listed in the defendant's financial statements, the bank looked for ways to keep the deals alive. He described how it worked. The appraisal would come in low. he would contact a defendant. The defendant would offer an explanation, market trends, special features, redevelopment potential, upside not reflected in the appraisal. And instead of holding the line, the executive would accept those explanations and move the loan forward using the client's higher number rather than the independent valuation. Even that testimony was devastating. It showed the defendant knew the appraisals were lower. It showed he personally offered reasons for ignoring them. It showed the bank officer knew there was a discrepancy and approved the loans anyway. But the question that broke the case open was even simpler. Did you actually believe those explanations? Long pause. Then he answered no. He did not believe them. He knew the numbers were inflated. But the defendant was a major client. The bank was earning substantial fees, and the executive was under pressure to close deals. At that point, the prosecutor introduced an email. The sender was the defendant. The subject line referenced a refinancing package. The body, as read in court, was blunt. He needed the property valued at $400 million to satisfy the required loan-to-value ratio. The appraisal had come back at $215 million, but, he said, we both know appraisers lowball. Then came the critical line. Can you make my number work? The executive confirmed he had received the email. The prosecutor asked what he did next. He said he approved the loan using the $400 million figure. That alone was bad. But then the government produced something far more damaging. Two versions of the same financial statement. The first was the clean final version submitted to the bank. It showed the property valued at $400 million. Professional, polished, official. The second was a draft the executive clearly believed no longer existed. On that draft, the original $215 million figure had been crossed out by hand and replaced with $400 million. Earlier in the trial, handwriting analysis had already linked those edits to the defendant. The prosecutor asked whether the executive had seen that draft before. Yes, he said. The defendant had shown it to him during an in-person meeting. He told him the appraisal was too conservative and asked him to accept the revised figure instead. The executive agreed. Then came the question that shattered any remaining ambiguity. Did the defendant instruct you to ensure that the final version submitted to the bank contained no reference to the original $215 million appraisal? The executive closed his eyes, took a breath, then said yes. He said the defendant explicitly told him the bank should only see the $400 million figure. No mention of the lower appraisal, no paper trail showing the real number. And then he said the sentence that buried them both. I falsified everything for him. Not just that property. Everything. He went on to describe a pattern stretching across years. Multiple properties. Multiple loans. Every time an independent appraisal came in lower than the number the defendant wanted, they worked together to make sure the bank saw only the inflated value. The executive would initial the file, approve the package, and the loan would move forward. What did he get in return? More business for the bank. Better performance numbers. Bonuses. Promotions. Recognition. The prosecutor asked how many loans had been affected. He estimated at least 14. Combined value? Nearly $2 billion. Estimated financial benefit to the defendant? Roughly $200 million in reduced interest costs over the life of the loans because the inflated valuations qualified him for more favorable terms. From a legal standpoint, that testimony was catastrophic. False statements to a financial institution? Proven. The executive admitted the valuations were false. Knowledge. Proven. He testified that the defendant knew the appraisals were lower and personally directed him to hide that fact. Intent to deceive? Proven. The defendant allegedly instructed that only the inflated numbers be shown to the bank. Materiality? Proven. The executive said plainly that the loans would not have been approved on those terms if the accurate values had been disclosed. Every major element of bank fraud was now supported by a first-hand insider who had participated in the scheme. And then it got worse. The executive described conversations with the defendant that sounded like premeditated fraud. In one from 2020, the defendant allegedly said, "Banks never really verify these numbers. As long as we stay consistent, nobody digs deeper." In another from 2021, he allegedly said, "If this ever comes out, you'll say you trusted my numbers. I'll say I trusted my accountants. Nobody takes the fall." That is not sloppy bookkeeping. That is evidence of intent. It suggests awareness of wrongdoing and a plan for how to deny it if exposed. Defense counsel tried to recover something on cross-examination. He asked whether the executive was testifying to save himself from prosecution. No, the witness said. He had not been charged. Did he have an immunity deal? No. So why was he testifying this way? Because, he said, the guilt had been eating at him for years. The attorney pivoted. You initiated many of these loans yourself, didn't you? Yes. And you profited from them? Yes. So now you're blaming my client for decisions you made? That is when the executive delivered the answer that ended whatever hope the defense still had. I made decisions, terrible decisions, but I made them because your client told me exactly what numbers he needed, exactly why he needed them, and exactly how he wanted the paperwork to look. He showed me the altered drafts. He told me the banks wouldn't check. I'm guilty of fraud. So is he. Defense counsel pressed one last time. If you knew it was wrong, why did you do it? The answer came back in one word: greed. That answer mattered. A lot. When a witness admits his own criminal conduct, with no immunity, no plea bargain, and no guaranteed benefit, juries tend to believe him. He was not minimizing his role. He was not shifting all blame elsewhere. He was implicating himself just as directly as the defendant. That is the kind of testimony jurors remember because it cuts against the witness's own interests. The prosecution ended with one final question. Knowing everything you know now, do you believe the defendant intentionally defrauded the bank? For the first time that day, the executive looked directly at the defendant. Yes, he said. He knew exactly what he was doing. So did I, and I'm sorry I helped him. The judge immediately called a recess. When court resumed, the defense rested without calling a single witness. That tells you everything. No valuation expert was going to undo a bank executive confessing that he falsified records at the defendant's direction. The defendant could not safely take the stand without risking destruction on cross-examination. So the defense stopped. No witnesses. No alternative theory. Just rest and hope. It will not be enough. I've been doing this too long not to recognize a finished case when I see one. That testimony ended the trial. The jury heard a senior banking insider admit to years of fraud. They heard him place the defendant at the center of it. They heard specific instructions, specific documents, specific conversations, and a direct confession that the entire paper trail had been manipulated. You do not recover from that. Closing arguments will be procedure, not suspense. The prosecutor will replay the testimony. She will put those altered drafts back on the screen. She will remind the jury that they do not have to rely on speculation, because the person inside the scheme has already told them exactly how it worked. The defense will argue that the executive is scapegoating the defendant to save himself. But that argument is weak on arrival because the witness had no deal, no immunity, and no protection from prosecution. In fact, by confessing in open court, he likely exposed himself to charges. Based on everything described here, I would expect a conviction. And when sentencing comes, the numbers matter. If the fraud produced approximately $200 million in financial benefit, federal sentencing guidelines will treat that very seriously. Depending on the full record, the defendant could be staring at a sentence in the range of 15 to 20 years, potentially more if the court finds aggravating factors such as the duration of the scheme, the sophistication of the fraud or abuse of a position of trust, and the executive. He is almost certainly not walking away either. The prosecution did not need to offer him immunity. He confessed under oath to criminal conduct in a federal courtroom. The U.S. Attorney's Office will review that testimony carefully, and I would be surprised if charges do not follow. He may eventually receive some credit for cooperation, but that does not erase what he admitted. He chose confession over self-protection. That may ease his conscience, but it is still likely to cost him his freedom. That is what makes this moment so extraordinary. The defendant appears to have assumed his co-conspirator would stay loyal. Instead, the evidence became too overwhelming, and the man who helped build the fraud destroyed it from the witness stand. I'll update you when the verdict comes in, but based on this kind of insider testimony backed by documentary evidence, I would not expect lengthy deliberations. This case will likely be remembered as a textbook example of why financial institutions must independently verify asset valuations, and why anyone involved in fraud should never assume the person beside them will stay silent once the documents start speaking louder than they can. And that raises the final question. When a co-conspirator breaks in open court and confesses everything, is there really any defense left?